So, at least it is sorted, at least we averted a serious issue, Daphne, in that. But the fact is, the gas account, as we heard, wasn't in Daphne's name, it was in her husband's, and that was another complication. And it's not the first time it's happened to Daphne.
Well, I've come across this before, where, you ring up and they say, no, I can't talk to you, you're not the account holder. Well, in this case, normally you can go and get your husband or whatever, and he'll say, yes, go ahead, speak to my wife. But my husband was in hospital and his speech isn't very good anyhow with the Parkinson's disease. And so as a result, they wanted me to send proof. They were sending me a stamped addressed envelope, which I had to wait for in the post. Then I had to photocopy my evidence and then send it in this stamped addressed envelope back to them.
With your husband as ill as he is it something that you've thought about getting enduring power of attorney or the right to speak for your husband or to manage his bank account or to speak on behalf of the account holder? Is it something you've thought about?
Yes, I have thought of that, but unfortunately we hadn't got power of attorney, and my husband being unable to do his signature and everything, we've gone past that stage now, and we have actually at the moment applied for controllership of his estate through the courts, and that's ongoing at the moment, but it's taken a long time for that as well.
Is it something you wish you'd thought about sooner, maybe when your husband was less ill, because he's been ill for quite a long time?
Yes, I think everybody should have power of attorney. It should be made nearly compulsory to have.
Now you're in the situation where you have to go through much higher and more difficult hoops going through a court. Everyday life, when you're not the account holder, can be quite difficult.
Yes, very much so.
What other areas have you run up against?
Well, the phone bill, but it's sorted now. My husband was here at that time and was able to say, yes, speak to my wife. But it's not always the case that he's here.
And able to speak.
And able to speak, exactly. Now, as I say, we've gone past that. But once the power of the controllership comes through, I will be able to do all that without having to prove anything that I'm his wife.
It's not easy to accept that after all this time that you're going to have to go through courts and legal things just to do what a husband and wife might normally do.
I know, and it's costly as well, very costly.
So enduring power of attorney, if it had been something you'd thought about sooner, did you think of it? Yes,
we should have thought about it sooner, and a lot of people don't think about enduring power of attorney, and I think it's a compulsory thing. I know my daughter in Canada, when she and her husband got married and went out there, that was the first thing they were asked to do. They just automatically do it in Canada.
And they're very young then?
They were young then, yes.
But as we grow older, it's something maybe more of us should think about.
Absolutely. I've told many friends since then about my situation and how stressful and waiting and all this is, and I hope they've taken my advice on board.
Daphne, and she knows what she should have done, and that's the problem. You think about it maybe a little too late. With me, Solicitor Michael Robinson, spokesman for the Law Society. You have to prove I'm his wife, she said. What do you have to do in situations like that if you want to speak on behalf of someone else?
Well, I mean, there are data protection issues surrounding everything, and if you're dealing with a public utility company like that, of course the issue is who are you and do you have authority to act or ask questions for the person who owns the account. So I suppose it's not altogether surprising that they take that prudent measure. I think if they didn't, we'd probably criticise them on the other side of that, you know.
So would enduring power of attorney help in this situation?
Yes.
What exactly is it?
Well, an enduring power of attorney is a document that you sign while you are capable, while you can make decisions for yourself, and when you sign that document, you choose and you appoint people who you would like to act for you in the event that you become incapable of acting. And incapable could be some mental disease, dementia, Alzheimer's. It could be that you're mentally incapable because of serious illness or something like that. So when you're capable, you select and choose on a legal document the people that you want to act for you in the event that you become incapable.
And let's just clarify, we're talking enduring power of attorney, which is Northern Ireland, and in England and Wales, it's lasting power of attorney. They're different. What does enduring power of attorney operate for?
An enduring power of attorney in Northern Ireland, I have to say, is really a simple document. It's a 4-page document. It can be completed very simply indeed. And it just is a choice. You choose someone who you want to appoint to act for you in the event that you become mentally incapable. At the point when you become mentally incapable, the people that you select to do that register it in court, and that registration gives them the legal authority to act on your behalf. You produce that document at the utility companies, at the banks, building societies, wherever you need, and that gives people who you've chosen the legal authority to act for you.
So Joanna has phoned in. Do you have to register it in court? I mean, you do it with a solicitor. Do you have to do something else again?
No, an enduring power of attorney unusually is effective as soon as you sign it. So
in the
during your
office.
lifetime, if you were away in Australia, you can actually ask the attorney to use the enduring power of attorney. But if you become mentally incapable, at that point, the enduring power of attorney must be registered in court, and that is the absolute protection that your interests are being looked after and that someone's not just cleaning out your bank account.
So it's maybe something that would be worth thinking about while you're making a will. But before you get to that stage, there are things you can do that maybe would help if you don't want to go that far. I mean, you could change your bank accounts into joint name. You could set up a third-party mandate. You could do all sorts of things to make life easier.
Yes, there are ways to do that, but the enduring power of attorney allows you to select who you want to do that. If you're married, I suppose one of the simple things would be to have a joint bank account or something like that. If you're not married, it becomes more complicated, and you're not necessarily going to want to have a joint bank account with someone who you're not married to. The benefit of the enduring power of attorney is that at the point when you are no longer capable, it has to be registered in court, and that's the protection that whoever is appointed will act appropriately. And of course, you could be dealing with property. So if you're married, and you've become mentally incapable, for instance, you might have to go into nursing care, you might leave your wife at home in a large house, she may need to downsize. Even if the property's in joint name, she can't do anything with the house because she can't sign the documents to transfer ownership or to sell it and downsize and release the capital. So really the enduring power of attorney, for instance, could appoint her to act for you in that event and gives her the authority to sell the property.
So you should think about it sooner rather than later, and unfortunately
absolutely.
Daphne left it a little late, although they had thought of it. They're now having to apply for controllership through the court, which she says is expensive.
That's a very complex and expensive process. That is the default position. If you haven't done the enduring power of attorney and you haven't selected yourself, then you have to apply to court for a court order, which is a controller order. That is a complex and very expensive process. So the simple thing to do is do the enduring power of attorney. At some stage we think that Stormont in the next couple of years might actually change the law and remove the right to do those in Northern Ireland. If you do it now, they can't retrospectively take the right off you later. So our advice to everybody would be to go out and do one. They're really cheap.
So enduring power of attorney is quite quick and quite easy. Solicitor's office.
They're very inexpensive to do. The lasting power that you were talking about in England, which is a similar thing in England, is very, very complex. In England they cost like 1,500 quid or something like that.
So nobody will want to do that.
And they're so complex that 1 in 3 of them actually fail because the wording is bad. Here this is a very simple 4-page document. You can actually do it yourself. You can go into solicitor and get it done at a solicitor's office. It might cost no more than £100, could be less than that. So it's really well worth doing.
Does it look like we're going down the road of lasting power of attorney? I know the papers are with Stormont. They've been looking at consultations for a while.
Yes, I think things are sort of generally moving in that direction. Whether that's a good thing, we don't necessarily think it is.
So that's the future. We'll have to see. So think about it today. It's not a bad thing to do. It's not an expensive thing to do. Will it also help with, say, advanced care directives for medical treatment? Does it cover that, or is that the lasting power of attorney? No, enduring powers of attorney do not cover that. They just simply deal with property and affairs. If you're concerned about that in Northern Ireland, you need to be doing a living will or something like that. Now, you can certainly do those. And my advice is if you're concerned about the health issues, then you should be consulting a solicitor really with regard to a living will or something like that. Do you do that? People come in to make a will. Do you say, have you thought of doing this? I mean, it's something, we heard Daphne saying that her daughter had already made one, she and her husband in Canada. Absolutely. I think our default position as practitioners now would be if someone comes in to do a will, we would automatically say do an enduring power of attorney. It is such an inexpensive document to do, and the ramifications of not doing it are very complex and difficult. I acted for my mother for 10 years, an enduring power of attorney, cheap, inexpensive, very effective. And a caller, Linda, says, what happens if a husband and wife choose a friend and give them power of attorney and then they pass away before us? Can we choose someone else? Does it just die, the document? Well, you can appoint 2 people jointly and severally, and you might be better to appoint 2 people so that if one dies, then there's someone left. I mean, if there's no one named on the enduring power of attorney because they've died, the enduring power of attorney is not effective, so you're probably better to have 2. So it's something to think about today while you're well and able and hale and hearty. Don't wait till it's too late. Absolutely, absolutely. As I say, it's cheap, it's effective, and in Northern Ireland you can still do it. Do it. OK, well, Michael Robinson, solicitor's with me. If you have a particular question, you can pick up the phone 08459 555 678.